Hi, everyone. My name is Megan Ma, and I'm a partner at Weirfolds LLP, a law firm that's based in Toronto. Thank you so much for inviting me to speak with you today on training requirements under Ontario's accessibility laws. So I've included my contact information here and at the end of the slides. So please feel free to reach out if you have any questions regarding the presentation or any other human rights issues or accessibility issues or employment issues generally. So I've set out on the screen an outline of what I wanted to cover with you today. Generally speaking, I want to cover the obligations under Ontario's Human Rights Code. I want to provide an overview of the Accessibility for Ontarians with Disabilities Act 2005, which we also call the AODA for short. I'll discuss some of the integrated accessibility standards under the AODA, some training requirements under the AODA, and finally, I'll leave you with some best practices and key takeaways, as well as some training resources under the AODA. So to start off, I know this presentation was intended to focus on the AODA, but I also wanted to mention the Human Rights Code, because both the code and the AODA set out similar obligations regarding the accommodation of disabilities in Ontario. So the Human Rights Code protects against discrimination and harassment based on various protected grounds, including disability. And so today the focus will be on disability and accessibility, but I did want to flag that there are other grounds protected under the Human Rights Code that may be relevant in your practices. So the code generally applies to conduct in 5 different protected social areas, which includes the provision of goods and services, which of course, as hearing instrument practitioners, you would fall under that social area. You may also fall under the social area of employment in relation to any employees that you have in your organization. So the Human Rights Code applies to all private and public entities in Ontario, including individuals, private businesses, nonprofit organizations, and the public sector. Parties to a contract are prohibited from contracting out of the Human Rights Code, and this includes hearing instrument practitioners. So the code has quasi-constitutional status in Ontario and is really given a broad and generous interpretation. And so wherever there's an inconsistency or conflict between the Human Rights Code and another Ontario statute or regulation, the Human Rights Code will always take priority. Now, I've set out on the screen the applicable sections of the Human Rights Code related to services and accommodation. And you'll see that these sections list the protected grounds under the code that I alluded to earlier. So generally speaking, a failure to provide people with disabilities with equal access to public or private facilities could constitute discrimination under the Human Rights Code and could be the subject of human rights application before the Human Rights Tribunal of Ontario, or the HRTO. And that includes any failure to provide people with disabilities with services, including hearing instrument practitioner services or services that you all may provide to the public. Now, I've set out on the slide the general test for discrimination under the Human Rights Code. So to establish discrimination under the Human Rights Code, a claimant generally has to show that they have a characteristic protected by the code. So for example, the ground that we're focusing on today is disability. They also have to show that they've experienced some kind of adverse treatment or impact within a social area. For example, access to a service or a facility, or discrimination within the social area of employment. And then finally, that claimant would have to show that that protected characteristic was a factor in the adverse treatment or impact that they experienced. Now, I did want to flag that this is always assessed on a case-by-case basis, so there's no hard and fast rule, and the tribunal would usually look at the evidence in the specific circumstances and the specific set of facts in that case. So an example in our case is if a hearing instrument provider refuses to provide services to a customer because they have a guide dog or support person with them, this would likely constitute discrimination under the code because we have the ground of disability engaged, we have adverse treatment or disadvantage with respect to the provision of services, and we also have that protected characteristic being disability being a factor in that adverse treatment or disadvantage. Now, I also wanted to discuss the duty to accommodate. So, under the Human Rights Code, service providers have a duty to accommodate people with disabilities to what we call the point of undue hardship. Now, undue hardship is evaluated again on a case by case basis with regard to a couple of factors, which include cost, the outside sources of funding, and health and safety factors. The duty to accommodate under the Human Rights Code includes both a substantive and a procedural duty, which means that the tribunal would not only look at the actual accommodation that was provided, but it would also look at the process that the parties followed in order to arrive to that accommodation. So, for example, what communications were exchanged, what dialogue was exchanged between those parties to arrive at that accommodation. The procedural duty to accommodate involves obtaining all relevant information about the individual's needs and giving all due consideration to what, if any, steps could be taken to accommodate those needs. So the case law has told us that accommodation is a two-way street. So it's not only the accommodation provider that has obligations, but it's also the person seeking that accommodation who has obligations under the code. So, for example, a request for accommodation must be made promptly, and it must be properly and promptly addressed by the accommodation provider. In addition, an accommodation seeker, so that person who is requesting accommodation, does not generally have the right to have the perfect accommodation or their preferred accommodation. Instead, the case law has told us that they're entitled to an accommodation that really does accommodate those needs or those medical restrictions. It does not have to be perfect. It does not have to be their preferred approach. However, the case law has also told us that an accommodation seeker does not need to accept an accommodation that is unreasonable. So, for example, if accommodation is unreasonably restrictive or inferior compared to other options available to persons who do not require accommodations, if that accommodation is not reasonable, a court or a tribunal could potentially say that that organization has not met its duty to accommodate under the Human Rights Code. I also wanted to briefly touch on some of the implications of discrimination and a breach of the duty to accommodate under the Human Rights Code. So I've set out on this slide some legal and non-legal implications of discrimination and a breach of the duty to accommodate. So, for example, in terms of legal implications, sometimes we see enforcement by way of civil action, a civil legal action, whether that's at the small claims court or superior court level, and this could result in potentially substantive damages for an organization. I've also mentioned earlier the Human Rights Tribunal. So one way of a claimant attempting to enforce their rights may be to really bring a human rights application before the tribunal, and that again could lead to potential damages, could also lead to non-monetary remedies that could include an order for training or an order to implement policies, or even in the employment context, for example, in order to reinstate an employee. Now, there are also some significant non-legal implications that could result from an organization breaching the duty to accommodate or from discriminating against an individual under the Human Rights Code. And so a common non-legal risk that we see is really the impact that a violation might have on an organization's reputation. And this could have kind of a broader impact on employee or customer retention, as well as, of course, on an individual level, an impact on an individual's physical or mental health. Now, turning to the Accessibility for Ontarians with Disabilities Act 2005, or the AODA, as we usually call it. I wanted to set out some key definitions under the AODA because, as I mentioned, these two statutes, the Human Rights Code, which we've just covered, and the AODA, are two distinct statutes, but there are also some overlapping concepts and overlapping obligations that come out of these two statutes. So, generally speaking, the AODA governs the development, implementation, and enforcement of accessibility standards in Ontario. Now, the purpose of the AODA is to achieve accessibility for Ontarians with disabilities with respect to goods, services, facilities, accommodation, employment, buildings, structures, and premises by January 1st, 2025. So again, we're coming up to that goal that the government has set. And again, this is a separate statute from the Human Rights Code, and it is governed by a separate entity from the Human Rights Tribunal of Ontario. So the AODA is generally administered by the Ontario Ministry for Seniors and Accessibility. But as I mentioned, there are some overlapping concepts in both of these statutes. Now, I've set out on this slide the definition of barrier and disability under the AODA. And you'll see that these definitions are quite broad. For example, the definition of disability includes not only physical disabilities, but it also includes mental disabilities. And those disabilities that are set out in that definition are, again, quite broad. So similar to the Human Rights Code, the AODA not only has kind of broad definitions, but should be given a broad and purposive interpretation in terms of statutory interpretation. Now, I also wanted to touch on enforcement under the AODA. So we talked already about the Human Rights Code and potential enforcement of the Human Rights Code. But in terms of the AODA, there are several mechanisms available to the government or the ministry to enforce an organization's obligations under this statute. So the first one that we've seen is audits. So with respect to audits, the directorate works with the organization directly to ensure that they understand the key requirements that they're being asked about in the audit. And the directorate will also provide resources if needed. In general, any issues that come out of the audit are only escalated for additional compliance assurance activities when an organization is uncooperative or unwilling to file a report. Another enforcement mechanism that the government has under the AODA is inspections. So generally speaking, it's not necessary for the government to obtain a warrant. The inspector may enter during regular business hours, and the inspector may require the production of any document, record, or thing required to determine whether the AODA is being followed. In addition, the inspector can question any person who's present at the organization on any matter relevant to the inspection. And the inspector may issue a written demand for records or things that are relevant to the inspection. So again, we see some quite broad powers in terms of enforcement and inspections. And then finally, the government also, or the ministry also has the ability to order a director's order or administrative penalties. So the government may also order that an organization file an accessibility report that complies with the requirements under the AODA, or order that an organization pay an administrative penalty. Now, where it's determined that a major contravention has occurred, the government may order that an organization pay a daily penalty to a maximum of $100,000 in the case of a corporation, or $50,000 in the case of an individual or unincorporated organization. So we see here that the government does have pretty broad powers in terms of enforcing these obligations under this statute. I also wanted to touch on accessibility plans and reporting requirements under the AODA generally before we drill down into the specific obligations and specific training requirements. So under the AODA, large organizations with 50 or more employees are required to develop a statement of commitment to accessibility and make it publicly available. They also have to have a written accessibility policy available and again, make that policy publicly available. And they must also have a written multi-year accessibility plan and update it at least once every 5 years and post it on their website if the organization does have a website. Now, for small organizations, and those are organizations with less than 50 employees, they're required to create an accessibility policy and maintain those policies. So the obligations for smaller organizations are a little bit less onerous, but I do want to flag that there still are obligations related to accessibility plans for small organizations as well. Now, in terms of reporting requirements, if you're a business or nonprofit organization with 20 or more employees, you have to file an accessibility compliance report every 3 years. And so the last reporting deadline for these reports was December 31st, 2023. If you haven't filed a report yet, you're still required to file a 2023 report, even though the deadline has passed. And then the next reporting deadline will be December 31st, 2026. And the government has said that they'll post additional information on how to complete the report for this deadline in 2026. Now I want to get into some specific details on the integrated accessibility standards under the AODA. Now that I've convinced you all of the importance of compliance and kind of the broad ability of the ministry to enforce this act, let's talk about the specific standards. So the integrated accessibility standards include standards to help remove barriers for people with disabilities in 5 specific areas. And so these areas are set out on the slide, but they include customer service standard, the information and communication standard, the transportation standard, the employment standard, and the design of public spaces standard. And so for the purposes of our presentation and the work that hearing instrument practitioners conduct, today we'll primarily be focusing on the customer service standard, the information and communication standard, and the employment standard. So obligated organizations include the Ontario government, the Legislative Assembly, a designated public sector organization, a large organization, and a small organization. And I touched on this in one of the earlier slides, but I did want to flag that a small organization under the Act is defined as an organization with at least one, but fewer than 50 employees in Ontario, other than the government of Ontario. And then a large organization is defined as an organization with 50 or more employees in Ontario, other than the government of Ontario, the Legislative Assembly, or a designated public sector organization. So just keeping these definitions in mind as we go through the standards. Now, the customer service standard is probably one of the most applicable standards that applies to your practices. And this standard applies to every designated public sector organization and to every other person or organization that provides goods or services to members of the public or other third parties, and that has at least one employee in Ontario. So chances are that if you are operating in Ontario and you are a hearing instrument practitioner, the customer service standard will likely apply to you. Now, I've set out on the slide a summary of the requirements under the customer service standard, and I'll go into further detail on training requirements in a moment. But generally speaking, this standard requires organizations to establish policies, to have procedures in place regarding the use of service animals and support persons, to provide notice of temporary disruptions in service, to provide training for all staff. And again, I'll get into a little bit more detail on those training requirements in a moment. To implement a feedback process for any feedback that may be given by any customers or clients. And to have a process in place related to the format of documents and any requests for accessible formats of documents. I also wanted to talk about the information and communication standard. This standard sets out the specific requirements for organizations to create, provide, and receive information and communications that people with disabilities can access. So, among other things, the Information and Communication Standard requires organizations to ensure that any process for feedback that it is implemented is accessible, to provide accessible formats and communication supports in a timely manner upon request, to ensure that any emergency procedures, plans, or public safety information is accessible upon request, to ensure that their websites and web content are accessible. If the organization is an educational or training organization, which some of you may have that branch in your organization, those organizations are required to ensure that resources and materials are provided in an accessible format. And then if the organization is an educational or training institution, to provide educators with accessibility awareness training. And then finally, if the organization is a producer of educational or training material, to make those textbooks or training materials accessible for those learners upon request. I also wanted to touch on the employment standard today, as many of you may have or will likely have employees within your organization. So this standard would likely apply to you. So this standard requires employers to make their workplace practices accessible to potential or current workers with disabilities. And again, that includes potential workers as well. So I'll talk a little bit about the recruitment process in a moment. Now, this standard applies to paid workers, but not to volunteers. And under this standard, an employer refers to an organization that employs a person. So if you have at least one employee, this standard will apply. Now, this standard covers the entire employment cycle from recruitment to accommodation plans to performance management and redeployment. So, for example, every employer must notify its employees and the public about the availability of accommodation for applicants with disabilities in its recruitment process. So even when you're in the pre-employment stage, before you've actually given someone an employment contract, you do still have obligations towards those applicants who are applying for that position. And then when making offers of employment, employers must notify the successful applicant of its policies for accommodating employees with disabilities. So even if that offer has not yet been signed at that offer stage, we still have that obligation to communicate that accommodation that is available for them. Now, every employer must also inform its employees of its policies used to support its employees with disabilities, which includes, but is not limited to, policies on the provision of job accommodations, which take into account an employee's accessibility needs due to disability. And then in addition, employers, other than employers that are small organizations, must develop and have in place a written process for the development of documented individual accommodation plans for employees with disabilities. So again, those plans should be individualized. They should be based on that specific employee's needs or medical restrictions. And this obligation applies to employers other than employers who are small organizations. Now, I wanted to talk about training requirements under the AODA now that we've covered some of the different standards under the AODA. Now, in general, every provider of goods or services needs to provide training to all employees and volunteers. And so that includes paid and unpaid, full-time, part-time, and contract positions. So for example, even if someone is only on, a 3-month contract, you would still be required to train them. That also includes providing training to anyone involved in developing your organization's policies. So that would include managers, senior leaders, directors, board members potentially, and owners of a business or organization. And then finally, anyone who provides goods, services, or facilities to customers on your organization's behalf. So that could include external contractors or facilities or management companies that provide services directly to your customers under your banner. So when must this training be provided? So you have to provide this training as soon as possible after an employee or volunteer joins your organization. But generally speaking, I did want to flag that if you have branches or offices outside of Ontario, organizations are not required to train employees who work outside of Ontario. But again, you'll see that these training obligations are quite broad in terms of the individuals who need to be provided with this type of training. Now, what does this accessibility training actually have to include? So generally speaking, training has to be provided on accessible customer service. So we touched on the customer service standard earlier. Training must also be provided on work-related accessibility training that is relevant to your employees' responsibilities. So again, it really depends on that specific person's role and what their responsibilities are within their workplace. However, in certain circumstances, you may be able to provide general training to a large group of employees, even if their duties are slightly different. Training should also be provided on the Ontario Human Rights Code as it relates to people with disabilities. In general, we do also recommend that training is provided on general obligations under the Human Rights Code, not just disability, not just the ground of disability. It's usually important to provide training while you're doing so anyway on other grounds under the Human Rights Code and also on things like harassment and violence in the workplace. So usually we see training sessions that include all of those topics just for efficiency purposes. And then finally, training should be provided on any changes that are made to your accessibility policies. Now, what does accessible customer service training actually have to include? So I've set out on the slide a list of topics that training has to include. Uh, those can be your organization's policy on providing accessible customer service. So again, alluding back to our obligations that we talked about earlier, the organization does have have a requirement to implement a policy on accessibility. The training should also include how to interact with people with various disabilities, how to use equipment or assistive devices available in your organization. And this requirement may be particularly important in your industry as hearing instrument practitioners. The training should also include information on how to interact with people who use an assistive device or require the assistance of a service animal or support person, which again may be particularly relevant for hearing instrument practitioners and the day-to-day service that they provide to their clients or customers. And the training should also include what to do if a person with a disability is having difficulty accessing the organization's goods, services, or facilities, and what process they may follow to overcome that difficulty or to request additional accommodation. And then the training should also include the accessibility standards that we already touched on and the Ontario Human Rights Code as it relates to people with disabilities, which we already briefly touched on. So in general, staff should be trained on areas of accessibility standards that are relevant to their work responsibilities. And again, as I mentioned, this could vary depending on that individual's job description. So for example, an HR manager may require different and more comprehensive training than a cashier might, particularly given that an HR manager may be dealing with, for example, requests for accommodation from employees or requests for accommodation from customers. So it really depends again on that person's specific responsibilities. But there is nothing preventing you from providing that more comprehensive training to all employees, just to make sure that all of your bases are covered. And then finally, staff must also be trained when there are any changes to your organization's accessible customer service policy. So similar to what I mentioned in the previous slide. Now, there are also some record keeping obligations that I wanted to flag for you. under the AODA. So all large organizations must keep records of training. However, we usually recommend that all organizations, regardless of their size, keep these records of training because this can usually be helpful, for example, if we do have to respond to a claim. So if we're in a situation, for example, where we are responding to a human rights claim, and sometimes, as I mentioned earlier, some of the remedies that a claimant can be seeking in those types of claims include in order to implement policies and to implement training. So it's usually very helpful in those types of situations to be able to show that the organization, in fact, already has a comprehensive human rights policy or accessibility policy in place. And that training has already been provided to all employees or all staff members, including any specific staff members that may be mentioned in that human rights application or in that civil claim. So even though under the AODA, only large organizations are required to keep records of training, we do usually recommend that all organizations keep those records. And then I also wanted to flag that training records must include when the training was delivered, who attended the training, and how many people took the training session. Sometimes it's usually helpful as well to have a record of those training materials, again, in the event that we're in a situation where we have to respond to a claim, and then we can show that the training was comprehensive, that it was given to a broad group of employees, and that it did cover, the topics or issues that are related to the topics or issues raised in that human rights application or in that claim that we've received. Now, you're all probably aware of these types of tips, but I did want to include in this presentation some specific tips or best practices that you may use when providing services to people with hearing loss. And again, as hearing instrument practitioners, these are likely repetitive and you may likely be familiar with all of these tips, but I did want to flag these for you as these have been set out by the Ontario government and the Human Rights Commission as helpful tips that you can include in your training with respect to dealing with people with hearing loss. So these tips include making sure that you're in a well-lit area where the individual can read your lips, making sure you're in an area with reduced background noise or moving to a quieter area within the space where it may be easier for that individual to communicate with you. Asking if another method of communication would be easier. And then finally, speaking directly to your customer or your client and not to their interpreter if they are accompanied by one. In terms of providing people with disabilities with dignity, that is generally a best practice that we recommend in general, not just with respect to people with hearing loss. And then finally, I wanted to, before we wrap up, leave you with some key takeaways and best practices overall. Given the nature of your practices, again, you may already be doing these things and you may already be familiar with these strategies, but I did want to flag some of these best practices that we normally recommend to our clients and that the Human Rights Commission has also recommended. So first of all, we want to be careful about not creating any new barriers for our customers, our clients, or our employees. And when we're making policy changes, for example, we want to be conscious of those individuals and we want to look at those policy changes, potential policy changes through a human rights lens and through an accessibility lens. We also want to make sure that we are designing inclusively from the get-go. So again, when we're either designing a physical space or when we're designing or creating new policies or procedures for our day-to-day practice, it's usually much easier to design accessible processes and procedures up front, or even physical structures or physical design of a physical space up front, rather than to have to modify those policies or procedures or physical structures or layouts at a later time. So it is important, especially if you're looking at a revamp of either your policies or your physical space, to again look at that design through a human rights lens and through an accessibility lens. We also want to favor integration over segregation. So as much as possible, we mentioned quiet spaces earlier. If we're able to create that quiet space, um, in a broad area of our space rather than kind of a separate back room, that will always be favored. Again, it's about providing individuals with disabilities with dignity in terms of their interactions and their experience with us as service providers. I also wanted to flag that equal outcomes sometimes require different treatment. So again, this goes back to the difference between equity and equality. So sometimes we don't always have to or should treat everyone completely equally in order to accommodate those needs. Usually, when we're talking about the duty to accommodate, again, we're talking about individual case by case basis. We need to look at that individual's specific needs and see what accommodations can be tailored to accommodate those needs or those uh, restrictions or barriers. And then finally, in terms of a best practice, when we're talking about either developing policies or dealing with an accommodation request or designing a physical space, for example, it is really important to involve those who need accommodations and exploring those solutions and exploring what accommodation may be appropriate or reasonable in the circumstances. So again, this goes back to the earlier concept that I mentioned of accommodation being a two-way street. It should be a dialogue, it should be a back and forth between the accommodation seeker. So, for example, the customer or the client or the employee, and the accommodation provider, so the organization that will ultimately be providing that accommodation. And then finally, I just wanted to leave you with some helpful materials and training resources that I set out on the slides here that you may refer to when you're training your staff on your obligations under the Human Rights Code or the AODA, or when you're simply just looking to review some materials to refresh yourselves on these obligations under the Human Rights Code and the AODA. So I've set out these links here on the slides, and I believe you will be provided with a copy of the slides as well. So thank you again for inviting me to speak to you today. Please feel free to reach out if you have any questions or if we can be of any assistance with any human rights or employment matters going forward. Thank you.